So this is quite interesting, and I can't believe I've come across this by chance as well. This page, because Robert F. Kennedy was talking about wanting to make it illegal to intervene in people's political rights and freedoms. But the thing is that, so I've already stated in the other video, right? There's no doubt about it that in the First Amendment of America, the word abridging and its relationship to, the right to petition and the rest of the rights, you aren't allowed to abridge, no one's allowed to abridge the right. And that right in the First Amendment is carried over, and the word commitments in the 1688 bill, as I've kind of set out in the last video over quite a length of time, is that if you wouldn't be in a position to be prosecuted for something if you can't do it in the first place anyway, and if you were prevented from doing it, then you wouldn't be in a position where you could even be prosecuted for doing it. So people cannot, what the right does, prior to that 1688 bill, people were doing petitioning all the time anyway to either of houses of parliament. It actually is preventing intervention. It prevents an intervention. That is what it's for. It's nothing really to do with the person who's doing the petitioning, because they were doing it anyway. It is preventing an intervention and punishment. Not just preventing the punishment, but preventing an intervention from you doing it. If it didn't do that, there's no point having it, because that's what it actually does. And for Robert F. Kennedy to say that he wanted to make it illegal, it's already unlawful, because if it wasn't unlawful, you won't be stopping the other person from doing it. That's everything. Because if they stopped you from doing it, you couldn't do it. The only thing that enables you to do it is the other people preventing you from intervening. That's what it does. Now, the thing is that the Americans have lost the plot, and I guess if Robert F. Kennedy kind of means that he's reaffirming it, he wants to reaffirm it in law to make it absolutely clear, without doubt, then fair enough. But it is already illegal in America and in England to intervene. Now, what I've thought as well is this, right? I strongly believe that, look, when justice is doing the law, right? Because justice is not just a punishment. Like you've got policies, policing, right? Policing is making people comply with the law, but the police is usually when you've broken the law, right? Justice is usually, the punishment's administering justice, but only because to get justice, when you enter the legal process, you are actually trying to find out if someone did or didn't do something and what actually happened. You are examining and following the law. You are engaged in applying legislation, right? And also checking legislation. You are working with persons' behaviours in and around legislation and the consequences of not complying with it. And this is the thing is, when you are doing political rights, you are using legislation, you are working within and around legislation, and it has consequences for people who don't comply, which is why you have illegal prosecutions, the illegal, right? The illegal prosecutions, but also it says the commitments are illegal. So if you try and hold someone, so the thing is that if you if someone is obstructing the law, right, then this is the thing, like in the Criminal Law Act 1967, 4, 1 and 3, this is what I've said in my case, because I was pursuing criminals and investigating illegal road signage to obtain evidence, right, investigation. And that's why they intervened in it, took my driving licence off of me and obstructed me from doing it. So they broke the law. And also they gave false statements. Now, there is an offence for giving false statements already. There's already an offence for giving false statements, right? Now here, I wanted to look into this this offence, perverting the course of justice. It's quite a it's kind of like a really serious law. So, you know, when you say it's a perversion of the course of justice, it's quite a vague thing. And what it says here, they knew that it was, well, the thing is, I don't think many people get prosecuted for it. And they've actually, the 12th of July, which is 3 months ago, they've put some new guidelines through for this offence. It's quite an old offence and it's quite an infamous offence because I think less people get done for it. It's quite like a widespread net catch law, you know, perverting the course of justice, right? But they're giving more sentencing guidelines, but they're also giving some guidelines for the first time, judges and magistrates will have guidance to assist in sentencing, perverting the course of justice. And it's crossed out witness intimidation offences. The new guidelines will enable the courts to take a consistent approach to sentencing these offences. So it's trying to say that they haven't had a consistent approach. Well, that's pretty, to say that it's quite a serious offence, perverting the course of justice, and they've never had a serious approach before, it is a joke in itself. It says there currently no guidelines for this offence, perverting the course of justice, or limited guidelines in magistrates' courts, witness intimidation. New guidelines will come into effect on the 1st of October. So that was like last week. So they only just come into effect this month, right? So perverting the course of justice offences cover a wide range of conducts, from giving false information to police officers at a traffic stop, tampering with evidence, or giving false information during a police interview. Well, the thing is, what annoys me about this is that there's already an offence for giving a false statement. And Gordon Queen and Michael Pagella gave false statements in my case, right? Now, it's true that, you know, if you give a false statement, it's perverting the course of justice. But if there's already an offence for giving a false statement, you know, so does these guidelines give it more clarity of when it would be perverting the course of justice rather than just a false statement? It seems to be mixing the two up more and more now. I don't really think that members of the public would be perverting the course of justice that often, to be honest. I think everyone really believes perverting the course of justice would be done by the government, by magistrates, solicitors, lawyers, because I don't think that there is no, you know, the immunity, there is no statute law historical immunity from what I've read of, you know, lawyers, judges and magistrates. It's actually people engaged in political cases. Now, they codify and write immunities of the police into the law, but they're not really immunities, they're just things that the police are allowed to do that other people aren't allowed to do, more or less. Or actually people can do them if they're doing them for policing purposes, upholding the law purposes, like in the Criminal Law Act. And I don't think I am the legislation that they've written into modern law for immunities of people involved in like inquiries and so forth goes on the basis of them being witnesses and giving evidence and so forth, which does follow the basis of the fact that, the police are pursuing a case, or witnesses aiding the side in a case are, doing so forth. They're meant to have immunity, but the way that they're doing it now is, anyone giving false statements or false evidence or whatever is guilty of an offence, So as long as everyone's been honest in any type of proceedings, then they're protected. But what they're protected from, though, this is the thing, if you are, the whole point of immunities and things that you're allowed to do that other people aren't is kind of contradictive, particularly when the right to petition said all prosecutions are illegal. I mean, these are all charges, and there would only be prosecution if something was unlawful. It seems, obviously you don't want people to give false statements. Why create the immunity? Why have immunities in legal cases anyway? And they do give witness immunity. The Crown Prosecution Service have got assisting offenders when they're going to waiver prosecutions and charges if they help them out, like obviously clearly when you've got informers and things like that. So really, perverting the course of justice, you would have thought would more be for police, prosecutors, judges, because the public, the public only really come into if they're being charged with an offence which is already criminal in its own offence. Why would you need other offences? I mean, because all in most cases you give false statements, right? That's an offence. You can only really give false statements if giving a false statement is already an offence, right? I mean, you don't really get people aren't involved. What I'm trying to say is people aren't involved in police cases unless usually it's for purposes of giving a statement, unless you're being charged with an offence, right? So, and obstructing someone in an investigation is already an offence anyway. So, perverting the course of justice, usually you would have thought, misleading people, or I suppose, if the police is chasing after a criminal and you misled the police or something, sent them in the wrong direction, but really, when the police ask you a question, you're giving them a statement, and if that's a false statement, it's a false statement anyway. If the police is chasing a criminal down an alleyway and he goes left and you say he went right, you're giving a false statement. This is perverting the course of justice. I really, Sunak and Suella Braverman and Priti Patel, and I would say Starmer as well, I don't really think they know what they're doing. I think the standard of intelligence, with all these McDonald's and KFC and Subway culture, and the standard of movies and films, like the writing in movies and films, only certain high-profile people used to make movies, and they used to be very good quality. And now it's flooded with, college graduates. A lot of people say the quality of television and movies has gone down. It's kind of like all effects, special effects and flashy effects, but the content, the quality of the films, the writing, and the level has gone down. And I see that in government through legislation. Although they try to be clever, they try to use fancy language and words and special fancy effects in government, make themselves look important with fancy TV shows and so forth, presentations, announcements. But the logic in it and the rationality of it is lacking, and it definitely did used to make sense in older legislation. Now, it tells you, so this is only guidance though, it tells you that, You see, witness intimidation. What happens if, big corporate entities or companies are intimidating people through the use of advertisements, like on the mobile phones, or, smashing cars into walls, tampering with vehicles, or causing incidents in areas. This is kind of like the civil disobedience of the elite that R.F. Kennedy Jr. is referred to. But there is, so the act, so the guidelines cover two offences: perverting the course of justice, contrary to common law, and witness intimidation. So it's the Criminal Justice and Public Orders Act 1994, but I wonder what there must be an original Perverting the Course of Justice Act. You sentencing guidelines. I'm going to look at the act, actually. Hold on a minute. This is quite an extensive and long act. It's got all sorts in it. Looks like a very... Police escorts. That is a really, really long act, that. Hold on a minute. Right, so the word perverted only appears twice in this whole act. Can you believe that? The word to pervert only appears twice in the entire act. I'm sure there's got to be an older act, a more archaic act, like, an 18 or 1900s act for perverting the course of justice. So anyway, this is the first instance of it appearing. I can't believe that. They wrote new guidelines, right, when the word perverting only appears twice, right, in the whole act. Can you believe that? That does look like a bit of a mouthful, that act. I doubt Keir Starmer knows it off by heart anyway. I really doubt that he knows that entire act off by heart. You'd have to read it. Intimidation of witnesses, jurors, and others. Well, what about what about the intimidation of witnesses by judges? Like by telling them that, it's busy. I'm sorry, we're too busy in courtroom number 2. You'll have to plead guilty because only the guilty room is not busy. If that ain't perverting the course of justice, I don't know what is. It's too busy. It's too busy in the not guilty room. If that ain't perverting the course of justice, I don't know what is. Intimidating you by making you think that they're too busy to hear cases for not guilty pleas, things like that. I'll have that one as well. In fact, I think I should I'm going to send this. I'm actually going to attach this video to my casework report. I might have to put it on. Well, actually, it's a general discussion anyway. I'm going to submit this to the Judicial Office of Investigations because I remembered that in my first hearing, as part of the same case that I'm complaining about, they tried to say that they were too busy to hear. This is actually when I had a lawyer as well from Leicester. This was at Leicester Magistrates Court. They tried to coerce and persuade me to plead guilty because by trying to lead me to believe that I couldn't plead not guilty. I wasn't allowed to, or it wasn't possible because they were too busy. Because the other one courtroom was dealing with guilty cases and the other with not guilty cases, and it was too busy. If I ain't intimidating someone, I don't know what is. And then they had like a girl in there. Really, I should have been had my charges dropped anyway because it's legal to prosecute me. But they dropped the charges against some girl in another courtroom. She came out crying, saying, "Well, we're crying with happiness, like her case had been dropped, the charges have been dropped, or whatever." I'm like, "Oh, good for her." I mean, these things clearly happen, but not to the people they're supposed to happen to. Well, not all of them. So look, right. So here, if a person commits an offence, right? If he does an act which intimidates and is intended to intimidate another person, the victim. I think they need some more, they probably need some more guidelines on what the word intimidation means. I severely doubt these new guidelines for perverting the course of justice are a guideline to anything. He does the act knowing or believing that the victim is assisting in the investigation of an offence. Or if the witness or potential witness or a juror or potential juror in proceedings of an offence. So, I guess this might be what they're trying to pull Extinction Rebellion up when they're trying to hold signs up to jurors outside. But that's petitioning. If it's a political campaign, a lot of those Extinction Rebellion people aren't supposed to be prosecuted anyway. The prosecutions against them are illegal. So that just messes the whole thing up. I mean, because that is the courts and the government breaking the law, and then them now giving guidelines on people who are breaking the law when they're breaking the law themselves. And what about me? The whole legal process against me was intimidating because I was actually doing an investigation. I was pursuing criminals, and I got multiple. I got speeding tickets from Nottinghamshire and other ones when I hadn't even done anything wrong, and then they were like messing around with the legend signs on the motorway to intimidate me, putting the wrong signs up, all kinds of stuff. I even actually think that the incident itself with the lane closed was a setup. I think the whole thing was a setup. I think they planned to take my driving licence off me there and then, knew where I was going on my sat-nav and the whole route and everything, because the thing is I went to Preston on the weekend before and there was all these like police cars parked outside of the place. We went to like ceremoniously, kind of like the whole force there. It felt like as if like I'm going to lose my driving licence. Like obviously my investigation had been in the newspaper and everything like that. That's what it felt like. That was intimidating, the whole thing. I mean, and then after I'd had a run-in with Sir Peter Fahey and a run-in with Steve Finnegan. Multiple courts had shut down that had been to like Northallerton, Chorley and Halifax. So it was a big deal, really. When I've been advertising the petition in the London Evening Standard, it's a big deal. When I've got evidence of illegal road signage around England widespread, it's quite a serious thing, really. So it is intending thereby to cause the investigation or the course. So my investigation was caused to be obstructed. Well, it was obstructed because I couldn't continue with it, because I couldn't get to all the sites to investigate them without a driving licence. And the police were investigating it because I was investigating the police, perverted or interfered with. So there's already a definition for perverting the course of justice. So, I mean, the whole lot of them, or the police force and the judges, were perverting the course of justice against me, really. But what I want to look at in the wording of this is this, which is, so, intimidation of witnesses, jurors and others. Person commits an offence if he does an act which intimidates and is intended to intimidate another person, the victim. He does so the act believing that the victim is assisting in the investigation of an offence, or is a witness or potential witness, or a juror or potential juror in proceedings for an offence, and he doesn't. So it is to do with investigations. I was wondering that if perverting the course of justice, what I'm trying to look for, to be honest, I'm trying to find if it could be stretched to covering creating the law, if you're going about getting law made, right? Because if you're using law, a legal process in law, to get a law made, and that is interfered in, if you are, you and the public and your MP are lawfully acting to get a new law made, right? That's creating policies which are going to be policed, right? What does the word justice, is that only sentencing of crimes that have been broken? But the thing is, if it is illegal to, if all prosecutions against you for petitioning are illegal or a commitment, right, then that's an illegal act. The thing with petitioning is this: it is a legal process. Now, I know there's civil proceedings, right? So what about perverting the course of justice in a civil case? Because that's not a prosecution, right? In a civil case, right, what about giving false statements in a civil case? Or the thing is with a civil case, right, a civil case really still has an investigation, because you can have a jury. They're saying that civil cases are meant to have jury traditionally, but they stopped having them. But in law, they're saying you can have them. It's possible. There's a framework for it, but they kind of sort of tried to phase it out or got rid of them. So, I mean, let's take, for example, divorce, right? Because I like the divorce framework, because you can get divorced with, if there is, infidelities and so forth. So, but with the infidelity, you got to find out if your partner's cheating on you. Now, it might not be a criminal offence, but you need an investigation. So you have to investigate, right? Let's say your wife's having sex with another man, and you get evidence of that. I don't know if you film them or take a photograph, a private investigator or whatever you want. And then with the evidence of infidelity, because what happens if they were lying to you and trying to say they weren't infidelity, once you've obtained the evidence, then you can get divorced, because there are certain criteria you've got to have to get divorced. So you've got a piece of evidence, right? And you go to court to get divorced, because, the priest doesn't divorce you in the church. It's civil. They only bring you together. They don't separate you. So then you've got a case, and you are wanting the judge to judge in your favour to get the divorce, and you put the evidence forward, right? Because they might not always do it, Sometimes I don't think people always. You're not always successful in divorce. It can fail, The procedure can, if you didn't meet the criteria for it. You definitely, this is what Vobes has been talking about on his channel, the tradition of jury in civil cases, and why the whole business sector kind of became corrupt. Probably would have become less corrupt if the public were involved in juries, with these big enterprises and so forth, and money claims and so forth, settlements. So what about if you're in a civil case and you lie? Not just giving a false statement. Like I said, that's a separate offence anyway existing. Well, I suppose you can intimidate jurors in civil case as well. So you could have perverting the course of justice in a civil case, but that's not... in this, it's making it sound like it's only a criminal case, right? Because it's like talking about investigation. But like I said, you can have an investigation for a civil case, because if the judge won't let you get divorced unless you have evidence, then you might need to get a private investigator. Now, legal proceedings, this is the thing. A petition to the government is legal proceedings. When you read the Professor Karen Bowie paper, the whole thing, the whole process was, like Lord of the Rolls or justices in the grand jury, magistrates of London and so forth. And, the King's Bench Assizes. This is a legal proceeding. The thing is, you don't just have civil and criminal proceedings. You have political proceedings that are proceedings in connection with the Palace of Westminster. And I know they've made a lot of changes and so forth, and Gordon Brown with his Appeal Jurisdiction Act and being repealed. You never needed that act. You never needed the Appeal Jurisdiction Act to get a pardon or appeal a case to petition the Lords over a criminal case. You could just do it. You could just do it because you got the right to do it to either House of Parliament or the King. You never needed the Appeal Jurisdiction Act. The Appeal Jurisdiction Act creates nothing. It merely is a procedure and formality attenuations. It's kind of like the criminal procedure rules and civil procedure rules. If you repealed the criminal procedure rules, there's still the Magistrates Court Act and other acts. It would just make it more vague, and that's what they're saying, that they're wanting to make this Perverting the Course of Justice with more clarification. You can't strip the whole system down by taking one act when it's built up from multiple acts. The Appeal Jurisdiction Act, to petition the Lords, really, there is nothing stopping you appealing any case to the Lords, really. Nothing, really, because you didn't need that Appeal Jurisdiction Act in the first place. It's not required. It's like, it's like a spoiler on a car or a fender. It's just like a fancy thing, makes the car perform better or go faster. The criminal procedure rules just make criminal proceedings, there are other acts which, and then there's the whole basis of bringing a case itself. A petition is a case. You could still, you could petition, if you removed the criminal procedure rules, you still got a right to petition His Majesty's government over anything, even a criminal case. So it's not so easily taken down, This is the thing with Gordon Brown. A lot of these ministers are just tinkering around. They're just tinkering, poking and tinkering with it, really, which is the problem. So, Perverting the Course of Justice, surely civil law is something just. In a civil case, doesn't the judge administer justice? If someone has been unfaithful to their partner, is it not justice if the partner gets a divorce that they seek through law? Is that not justice? They've been cheated upon by the partner and they want relieving from the commitments of the marriage vows and so forth. Is that not justice being delivered? Surely it is. And this is why, in petitioning the government, surely, right, if the creation of the law, the conceiving the law, citizens, if there is no law, right, and someone has been punched, and they say, right, this is theory, by the way, but it's valid theory, and they say, right, I've been punched in the face, I want this person to be punished. And you say, well, through what principle, what procedure? And you say, well, can we make a law up now to say that that person isn't allowed to punish me, and if they have punishing me, it should be illegal, right? And once you make that law, then you can prosecute them and obtain justice. So by making the law, you create, not only do you create the justice, but then you can obtain it, right? You can obtain justice. So surely, if you intervene in the creation of the law, then you are perverting the course of justice, because you are trying to stop someone from creating a law that is going to make something illegal so you can get justice, or so other people can get justice, surely. So, like, the right to petition, surely, if the right to petition and all prosecutions for doing so are illegal, if someone prosecuted illegally for petitioning when they're trying to get a law made or changed, then surely that's perverting the course of justice, because the course of justice, to be on a course, to be on a course to set sail on a voyage, for justice, is to get on the ship. And if you ain't got a ship, you can't get there. To embark upon the journey of justice, you must set the first step. Really, So surely petitioning the government to get a law made or changed, or particularly if you're petitioning for a public inquiry, because that is an investigation into something wide scale, surely intervention in that is perverting the course of justice, surely. So if that's the basis, then I think that intervening in a petition case surely is perverting the course of justice, because, like, if someone isn't going to sell you any paper, right? Right. Let's go back to the criminal case again. If we go back to the criminal case, right? So, if you're a lawyer and you are, someone comes to you to represent them in a legal case, criminal case, and you ain't got any paper or a pen, and you need to go get paper and pen, and the person in the shop won't sell you it, surely, if the lawyer can't do the legal case, he's been obstructed from legal representation and engagement. So surely, if W.H. Smith refuses to sell paper to a lawyer for legal purposes, when they're selling paper to anyone else who is not using it for legal purposes, surely that's perverting the course of justice. Almost like, if you're in a police, how is that any different to being in a police interrogation room, and the police have run out of paper, and they need to write a statement down, and W.H. Smith won't sell the police paper, so they can't write down a statement. Surely if W.H. Smith refused to sell the police paper, that would be perverting the course of justice as well, which is why I strongly believe that you can't do police work without having paper. And if you're refused to be sold it when you need it for statements, then surely the shop is perverting the course of justice. And this is why, same for right to petition, because, if you're getting a law made or changed, and you need to write it down for that purpose. So this is why all commitments and prosecutions are illegal, because you wouldn't even be able to be prosecuted for petitioning if you had written the petition. And if someone won't sell you the paper, right, then how can you write it down and then get prosecuted for doing it, even if it was, so you can't even embark upon the journey to even get anywhere close to doing any of these things if people are going to refuse services. And I think they'd already figured this in, and it was a no-brainer part of it. It was obvious, and this is why YouTube and Facebook and other publishers aren't supposed to deny service, particularly when they're supplying it to other people. And this is why, like, they already know this in the law. That's why it says, make available you know, to publish means to make available in any form and by whatever means. Well, you know, you can publish it yourself if you get a pen and you can sit there and write out 10,000 copies yourself. You don't need a printing press. You don't need a newspaper printer if you're going to write it out by hand, because theoretically you can write out 10,000 copies by hand if your arm's not aching, if you've got the time, or you could just, you know, upload it to the computer or print it on a printer. You know, it says by whatever, in whatever form and by whatever means, or even put it on YouTube and it says make available to the public at large or a portion of the public. So I actually, let's look at this second part of it. So, offences under the law of Scotland. Treason, attempting to pervert the course of justice. So that's all it is. Threats, theft, embezzlement, extortion, fraud. I wonder if they could have defrauded us in the court when they said that courtroom was full and I couldn't plead not guilty because they were too busy. But I did end up pleading not guilty because I was adamant that I was not guilty. And that's when they put in that's when they actually, my lawyer actually said, you know, I'm claiming special rights, protection, immunity, and I actually got it granted that I was claiming it and that it was eligible to claim, that it was viable. You know, it's not like they don't entertain these ideas if it's completely and totally nonsensical. So this is at Leicester. You know, that evening when I left, I was like, that was like the land of hope and glory. That was like the the legal basis had been officially submitted and accepted for a very, very special hearing, of which I was not defending a charge. I was actually putting getting a right validated. I wasn't defending the charge, and if I'd have had it validated, I wouldn't have been facing the charge. So that evening, when I left the courtroom, I think my lawyer's solicitor was as surprised as I was. That was really but I had all my time taken off of me because, you know, I was supposed to have like a month then after that to prepare, and then he made some excuse up that, you know, he'd got other things on his plate, and then I only had so many. I think I had to go to Telford for something else, and then after that, then something weird happened, and then they took all my preparation time away. He made some excuse up, like, he got other appointments and so forth, and so I was kind of hustled. I think that was all fabricated, or someone had messed with my judge's timetables or something like that. Because, you know, I could have said, well, no, that's not convenient for me. Well, if you can't have it on that date, well, you can extend it even longer, not shorter. You know, I think that was a fraud, or even maybe intimidation. But anyway, so here we've got, look, just attempting to pervert the course of justice. It's just listed there. It's listed under you. So it's just attempting to pervert the course of justice. I wonder if it tells you at the end of the act what the word justice in this act means. This is in with possession of shotguns. Can you believe that word, that perverted, is only mentioned twice in this entire act? Never mind talking about being vague, but it's a well-known thing, perverting the course of justice. I mean, people mention it a lot. I guess it explains itself, though, doesn't it? You know, civil. You see, there are many, like, what about the civil procedure rules? You see, the civil procedure rules are. That's the course of which justice should be followed. And there are many times when a rule's not followed or ignored or not obeyed, and you've got to call it. You know, in a court case, when certain procedures aren't followed, usually you've got to call out the other side and say this wasn't done, that wasn't done, and then they're meant to correct it, or if if they took time away from you, correct. Like Sam Guzzi. Sam Guzzi gave me the wrong time at Huddersfield, and when I turned up, they'd already had the case. So my lawyer had to go back and say, just a minute, I had the slip signed by him, and I've still got it, a scan of it on my computer. I think I might have submitted it actually to the investigation. So, that's perverting the course of justice, giving someone the wrong time to attend court, so they miss a hearing. Sam Guzzi, but then he ended up going to the local advisory committee, and then working his way up to DJ Guzzi at Manchester, and the next thing he's at Southwark Crown Court. These people climb. When you go after these people, they climb like on a boat, on a ship. Climbing the riggings up to the crow's nest. When you chase them, they climb higher. So that's all it says. It's just listed there. I'll look in the we'll look in the dictionary. Although I've got the dictionary at the side of me, but I'll look online. Hold on. Although the thing is, the ironic thing in all this, if you are like the true, this is Merriam's, it's not Cambridge or Oxford. The thing with all this, right, is that if you are a true intellectual, if you are like a true intellectual, like contemplator, a true kind of like, academic, perverting the course of justice, I mean, the thing is, when you pay a defence lawyer to defend you, their job is to defend you and try to prove you're innocent. Supposing you're telling the truth the whole way along, you plead not guilty or whatever. So I find it ridiculous that, how can you have a defence? Because, you're pleading not guilty, and it's your defense, if your solicitor's job to try to prove that you are innocent and make a case for it. But what if you're not? This is the thing, that really, implicates the defense lawyers, because, how can you even put up a fight or attempt to prove not guilty, but if the defendant says they're not guilty and believes they're not guilty, but what if they truly believe they're not guilty and they say they're not guilty, but the lawyer, the solicitor, thinks that they are guilty and advises them to plead guilty, but they themselves don't believe that they are guilty? How can the solicitor continue with the case, Maybe that's kind of what my solicitor was thinking when she was trying to get me to prove guilty, but I was adamant. I'm like, no, look, but she put the right across and we had it accepted. So, I mean, I think I'd done the right thing. There is a certain, I think black belt barrister will probably get into the nooks and crannies of this and into the kind of like complicated sparring of it. But theoretically, I mean, I know there are certain implications in the relationship between defence lawyer, but if you're paid them to defend, and that's their job, their task, they've got to try prove you're not guilty once you've paid them, and on your statements, they've got to use the statements and argument and their knowledge of the law to put a compelling and convincing argument to a jury. And if a jury decide that but the odd thing is, you look at the Ian Bray case. The Judge Gregory Perrins at Southwark Crown Court, he says to the jury the words, right? There is no legal basis, or he claims there is no legal basis for Ian Bray, right? And then the jury say not guilty. So can the jury be perverting the course of justice? Can the jury be perverting the course of justice if Gregory Perrins says there's no legal basis for the innocence of Ian Bray? Then Are the jury perverting the law? But they are it says intimidating the perverting the course of justice is only intimidating the judiciary. It doesn't actually say anything. Whatever if the judiciary, if the jury break the law, but apparently they can decide. They're in a position to decide. It all starts unraveling. This is why I don't think the current legal system is very good. It's almost like it could have been designed by Gordon Brown, the whole thing, with his pulling his Pre-Elect Jurisdiction Act, which is like pulling a fender off a car when it still drives, It's, I mean, and the worst thing with Ian Bray is that, I don't truly believe that they should have been prosecuted anyway. I don't know what particular criminal damage it was in the Ian Bray case. It was different. It's not when it's painting an advert. The thing is, a lot of these Extinction Rebellion actions are promotional. They are advertisements painting letters under Class C through use of the enactment Class F for petitions to government through the Town and Country Planning Act, and you use the enactment and you got the immunity. So under that act. It gets a bit technical with Gail Bradbrook smashing and breaking windows, but it depends if you can say they're making a representation, like if it represents, if it's saying like this is a representation to the public that's been filmed and broadcast as an advertisement, represents a broken planet or a broken world. You're getting into theatrics and presentations, public speaking, the whole thing is theatrics, so, it is a representation. Particularly if they're giving like an announcement for Extinction Rebellion, because making a legal representation includes, like in court, you are making a legal representation includes the whole performance, the questioning of the witnesses, professional witnesses, giving examples, hypotheses, giving a presentation of sometimes they act things out in court, if they want, to show how something was picked up, to prove he picked this up and he picked it up in a certain way. And, I haven't ever seen anything like that in a courtroom, not like Colombo when they're like going through it all in detail. Maybe they do. All the court cases that I've been in have been pretty shabby from the Crown prosecutors, very poorly presented, weak evidence. I watched the screen once. I've never seen any exhibits. Nothing like on, television when they go through, showing the jury how it could only have been possible to pick something up a certain way in their hand and all this other stuff like that. It seems like that's reserved for TV shows, But anyway, so justice. I wonder if justice could cover civil cases as well. So perverting the course of the law. Well, breaking the law. You're perverting the course of the law when you break a specific law. Well, this specific law says perverting the course, perverting the law. So you've broken the law, but then you're perverting the pursuance of the law being enforced or judged. I'm pretty sure that perverting the course of justice means that you're perverting legal proceedings, surely. Surely it must be synonymous with perverting legal proceedings. Because the thing with giving a false... This is how I'm going to work it out now, because I've just kind of clocked it a bit better in my mind. So... giving a false statement is you're actually writing a statement on paper, and that is a specific offence, right? Or verbally delivering a statement. That's giving informations. So perverting the course of justice can't be giving a false statement because it's got its own offence. And if a police officer questions anyone on the street, which way did the robber run, that's a statement. If they say he ran left when he ran right, you're giving a statement to the police officer, and that is an offence separate. And perverting the course of justice is more serious than giving a false statement, surely. Perverting the course of justice is proceedings. I strongly believe, and I don't even think that they've used this. You see, because the thing is, they assume that judges, prosecutors, and magistrates are all immune, but I don't think they are. You know, perverting the course of justice surely is it's the crime of of legal persons, because they're the ones who are working in. That's the thing that they're working in. We break normal laws if we break the law. These people who work in that sector surely pervert the course of justice when they break the law because they work in justice. I surely, if you break the criminal procedure rules with intent, not by mistake, surely that has to be a perversion of the course of justice, because that is something different to giving a statement. But then, if you said that, oh, I'm sorry, I forgot, right, or it was a mistake, professional negligence, right, when you did it with intent. Now, that would be giving a false statement, because if you did it with intent, if you purposely didn't follow the procedure rules, you could be given a false statement there, if you lie. But then there's perverting the course of justice by not following the procedure rules. Surely. It has to be, you know. So, I mean, any of those civil or criminal procedure rules not being followed. I mean, look at, let's take, for example, the way that I now, thinking about it, interpret perverting the course of justice is perverting the course of legal proceedings, surely. Because how could it be specific to criminal cases when you can have an investigation and obtain justice through civil cases? And some, like in the High Court, they can have both civil and criminal matters involved in a case, you know. Surely it's perverting the course of legal proceedings. That's how I think I've always seen it like that. Perverting the course of justice, perverting the course of legal proceedings, other than giving a false statement, which is an offence itself. I'm sure falsifying evidence has got its own offence. They never prosecute for breaking the criminal procedure rules, because they always claim that, it was an honest mistake, or it was just an error, like human error. I think that's why they get away with it most of the time in the prosecution, when they're supposed to give part of the evidence or this or that. So you could say that, you know, failing to give part of the evidence, when it says in the criminal procedure rules, you know, they have to give part of the evidence. If they refuse to do that, surely that should be perverting the course of justice, you know? And like the police often refuse to give the video or part. You see, the thing with the thing with like speeding fines, right, is usually you have the statement, but usually they only prosecute you mainly with the photograph and the statement. So you get the statement from the police officer and the photo, but they've got to give part of the evidence. But when they send the letter, they never really send the entire statement of the officer. They usually just like have the offence written out, like the charge, right? That's not the full statement of the officer. Now, when you give part of the evidence, right, if they can choose which part of the evidence, but, you know, they can take a photograph from a video and not give the whole video, I suppose that's giving part of the evidence. But the thing with the video is this. When you get the video, it's surely the... I've had this argument before with the police. The video itself is a piece of evidence, right? It shows the movement of the vehicle over time and its speed. Now, if you take a photograph from the video, a frame, you have tampered with the evidence and you've modified it or changed it, because it's not the original video. The thing with a speed camera is it takes two photographs. It's only designed to take two photos, right? But a video is a video. they say that they don't even need those videos, that, it's only for support or to prove it's your vehicle, So why does it have the speed reading in the top corner, and if it's a statement of the officer said, I used the device and I took the speed reading and this is what the speed is, it's all on the statement. The figures with those videos, they really, really make it look like, through the perspective of the camera and so forth, they really, really, really make it the what's it called? The depth of field is truncated through the camera, so it makes distances look a lot shorter than they are over in real life. Distances are a lot longer travelled. And a lot of those videos disclose like the van rocking around and actually where the true aim is, or because it's got the target on it. Sometimes they don't have the target on it, but you can even count the white lines on the road. There's lots of things that those videos can prove and be very, very beneficial to the defence. So therefore, giving that evidence over to the defence as part of the evidence will be very, very valuable to the defence, and could even prove that you're not guilty through the video, details in the video. So, but when it says give part of the evidence, I mean, really, I mean, I think in a criminal case where there's been a murder, right? So, like, there might be a jacket with blood on, there might be some fingerprints, there might be like, knife, there might be 3 statements. So when it says give part of the evidence, I'm sure that rule is so like, they're not going to give you all those things. Like, okay, we give you a statement and then some photographs, of a finger, of this or that. I think it's designed for cases that have like, multiple evidence exhibits. With like a driving offence, we give part of the evidence. Well, there's only a statement and, the video. So, now the thing is, in the criminal procedure rules anyway, the prosecution are meant to disclose anything that if there's something that could show that the defendant is innocent, that they're meant to disclose it or give it over. In fact, weighing up the scales of the law, they're not supposed to be prosecuting you if there's something that shows that you're not guilty. I think this is what there's just been a big court case over now, over like that guy who got put in prison for that sexual offence. The prosecution had something that could have showed that he wasn't guilty, but they never disclosed it. A lot of those videos that the police have got can show that people actually, weren't travelling at a certain speed when you actually see the video, or that the police gun wasn't aimed right, and so forth, or the van was moving all over the place and unstable. And really, they should give that evidence over. When it says you have to give part of the evidence, but I have all my videos, or I've got most of them, and they were not easy to get. They just did not want to give me them. It took like months and months and months, in some cases like a year or longer, to get all of the videos, and it was worth pursuing them. And I also got the police recording. That's part of the evidence. It's your own statement, and also like all the questions that you're asked. The solicitors get all these things usually when they represent you anyway, but the police really don't want to give any of these things to a member of the public. They really try to get out of it unless you badger them, and that's something that people should know. But you only know that if you encounter the police. All these things that not following procedure rules and not giving part of the evidence when it says, even in some cases they don't even really want to give the statement. So I think some of these things are perverting the course of justice, particularly when, it definitely says that they've got to do it. I know some people do get actions against the police. I find it very difficult when you ring up solicitors even to, they just either are too busy, or they don't have the capacity, or I don't know. I don't seem very. I don't seem to be able to get a spark going with any of them. Maybe it's because I kind of know what I want out of it, and if I think that the solicitor sounds like, you know, they aren't very proficient or they're jipping me off or whatever, I kind of like, you know, I think all these solicitors just want people to ring up and then, you know, let them take care of it. Okay, this is my problem, and then you want the claimant, you know, the client to just go, you know, yes, no, 3 bags full, whatever, not just like, we need to be doing this, we need to be doing that. Instructing a solicitor or instructing a barrister or whatever, I don't think these days they want to be instructed. They want to instruct you, which is what my solicitor was trying to do in my case at Leicester. She was trying to talk me out of, you know, pleading not guilty. And the judges as well, you know, by coming up with all these excuses like, oh, it's too busy. How can it be too busy to be not guilty? You know, only the guilty room is not busy. You know, the not guilty room's too busy. Stuff like this should be perverting the... I think it is. Because those criminal procedure rules are the law. The criminal procedure rules is legislation. It's meant to be legal requirements. So, you know, you would have thought that, you know, they were... I really think that should be perverting the course of justice, really. You know, because giving a false statement... surely, if the police have got evidence that, you know, someone could be proven not guilty, then if they're not handing it over, when they should be handing it over, what about that ridiculous culture of dumping the videos? You know, the police only keep hold of the videos for 5 years and then they get rid of them. That's kind of disposing of evidence. You know. If a lot of those videos could have proved people didn't speed, or if the police themselves have misused the equipment, that's like dumping evidence, you know. I think the Welsh police force kept hold of it for a lot longer. You know, I mean, you know, if I had £1 million, I'd want to, you know, I don't want to bring a case for that, you know, I mean, because all that video footage was evidence and they really didn't want to give it. And it would have proved a lot of misuse of the cameras, vans rocking all over the place, not aimed right, you know, counting the road lines that you're passing with the timer within a certain time, all that stuff. So, the maintenance or administration of what is just, especially by the impartial adjustment of conflicting claims, or the assignment of merited rewards or punishments. So punishment is a fine, isn't it? So it's actually to do with claims, conflicting claims. So so after all, I've been speaking for 1 hour and 7 minutes now. So so this Merriam's Webster dictionary would support my claim that perversion of the course of justice would encompass civil or other cases, because especially by the impartial adjustment of conflicting claims. Well, what about when you're trying to get a law made or changed? You're claiming that this should be the law. The law should be that smoking is illegal, or the law should be that, you know, I shouldn't be kicked in the head, and we make it the law, and then we have a debate, conflicting sides. You know, we think it is, no, we think it isn't. Conflicting claims from both parties. So surely, on that basis, there's a strong case for perverting the course of justice does equate to perverting the course of legal proceedings. And if it is perverting the course of legal proceedings, it would mean criminal, civil and political proceedings to Parliament, which we know from that Professor Karen Bowie paper, it is, they are legal proceedings. They are to be regarded as legal proceedings, which is 38 degrees. 38 degrees are hosting the petitions and they're taking them down. 38 degrees are a publisher of petitions on their own private website, but they are intervening in private messages that petitioners send, private personal messages regarding the legal case. 38 degrees are intercepting, obstructing, and sometimes withholding the delivering of mail messages between a claimant and the case workers, supporters. They're also taking evidence. So when I collect evidence for a petition, photographs and videos, so 38 degrees have unlawfully seized those as a third party when I'm making the case to the local council chamber or to Parliament. Surely that's perverting the course of justice. Because and then, you know, when I actually got some signatures and a person was supposed to be collecting signatures and they got me some false signatures, and 38 degrees even withhold the data from me, so I couldn't even check the data. I couldn't even look at it. They're withholding my data from me. That's perverting the course of justice, because they're my signatures. I collected them, and they won't show me them. I collected them, people signed up, but they won't let me see them. So I couldn't even see the email addresses. So how could I even check my own legal case to Parliament, the legitimacy of it, when 38 degrees were withholding the data from me? And then they seize my evidence when they're not even in a position to seize evidence, because it's my evidence. You know, the only person who has the right of the evidence is the Parliament, the council, or me. It's my case. Not some publisher who said, oh, I'll publish it for you, but then I'm going to take it off you, you know. So 38 degrees could be perverting the course of justice, and possibly change.org as well. So I think Professor Kennedy's wrong. That it's already illegal to intervene in petitions. That's why, you know, all prosecutions and commitments are illegal. Because this is what they were doing. They were trying to charge people money. They were doing all kinds of things to intervene in the petition process, which is why that right was created. And the thing is, it is legal proceedings to Westminster. It is legal proceedings to Westminster, and we have a right to initiate them as much as we have a right to go and switch the computer on, go onto the small claims court and put a claim in to a court that someone owes me £25 on the internet. If I list a case with Parliament, it's just the same. It is a legal proceeding under the realm of England, you know, Scotland and Wales. And it is a legal proceeding. It is a legal proceeding and always has been. And perverting the course of justice, it extends to, you know, all forms of claims, conflicting claims between parties. The thing is, though, the thing with political proceedings is because you've got like an opposition, you're meant to have this privilege of immunity because the opposition's trying to beat you, sort of thing. And when you set out from the onset, you are bringing the case. And this is why police have, you know, they're allowed to break the law. You know, but to what extent is breaking the law if people are just going to lie and be fraudulent? Well, I don't know. That's the thing. You know, they've always granted witnesses immunity when they're on the side of the person bringing the case, in case it would incriminate them in other offences. When they answer questions, right, they're meant to be there for those charges on that case, right? And it's not meant to, like, if they end up disclosing something they've done illegally to do with something completely unrelated, I think that it's meant to protect them from that, because, you know, unless it's in facts and circumstances to do with those events. It's like that double jeopardy of law, you know, you can't be prosecuted twice for the same facts and circumstances. You see, Manchester and Huddersfield police did that to me. like for one, putting stickers when I can do it anyway, because it's like, you know, an advertisement. They stitched me up like Angela Ditchfield and did it for criminal damage or putting legal notices by highways. I got prosecuted in Manchester and in Huddersfield for things that were the same events, the same facts and circumstances. You know, going and, you know, it was the same. It was the same events, the same associated activity. And they split it up into different charges and brought some in Manchester and some in Huddersfield. And in fact, I got them to drop some of those charges because one of the charge was in West Yorkshire, but they were putting it through Manchester Court. And because there's a border between the counties, and I said, no, you're saying that it's at this location, but the borderline for the county is at this place, and they couldn't charge me because I was out of jurisdiction on one of them. So they removed that from the charge list, the CPS in Manchester. So I was right about that, for sure. I'm trying to find that set of charges. I saw it on my computer and then I couldn't find it. It popped up on my computer and I don't know what happened to it. The West Yorkshire charges, there's quite a few. So I'm certain perverting the course of justice it has to apply to civil and political cases as well. And I think that, you know, if a police officer is pursuing crime and someone won't even give him materials, like what happens if all the public said we're not supplying the police with materials, you know? What if the civil disobedience started extending to retailers, the people who supply the police with materials, like we're not going to supply them with truncheons, or we're not going to, we're not going to supply them with equipment. What if the public, what if, people just said, we're not going to supply the police with truncheons or uniforms or anything, so they couldn't actually do the job, and that's the basis of the petition, because you've got to be able to have pen and paper to write it, and when it comes to publishing it, you've got to be able to, it's required to be published and to serve the function of collecting the signatures. It is proceedings. And that's why, really, my case is about the right to petition, and though it's about what does it mean and what does it actually really cover, and that is what we're trying to establish. All of the things that it covers, through the different acts, because you need to be able to do all those things in a typical scenario of a typical case, like putting notices up to assembling, moving around, obtaining materials, and publishing, submitting, and then for your MPs to debate the matter. It's different stages of a political casework, just like a criminal casework has different stages, from the questioning and the police investigation through to the courtroom, and then to out of the courtroom, even to, the community service and so forth. Well, rights apply through the whole process. Medical rights apply through the whole process, and political rights should apply through the whole process as well. So, according to this, I'm right about that. According to the dictionary, justice, the maintenance or administration of what is just, especially by the impartial adjustment of conflicting claims, or the assignment of merited rewards or punishments. Well, that includes like civil claims as fines. And then, obviously, if you're wanting to get the law made or changed, then someone's going to get a punishment once you've made it illegal. And also the reward, you've obtained the reward when you get the realm, the kingdom and the realm actually, updates its, how it functions with what you've been trying to pursue, you've been successful. Surely the reward of your campaign is having, your new law enacted or your subject actioned or your inquiry investigated or whatever it is that you've been petitioning for.